of the iceberg. I interviewed witnesses and survivors who described very similar killings in the departments of Antioquia, Arauca, Cali, Casanare, Cesar, Córdoba, Huila, Meta, Norte de Santander, Putumayo, Santander, Sucre, and Vichada. A significant number of military units were thus involved in these killings. Some officials continue to assert that many of the cases were in fact legitimate killings of guerrillas or others, but the evidence, including ballistics and forensic reports, eyewitness testimony, and the testimony of soldiers themselves, strongly suggest that this was not the case. The dangerous guerrillas who were killed include boys of 16 and 17, a young man with a mental age of 9, a devoted family man with 2 in-laws in active military service, and a young soldier home on leave. I cannot rule out the possibility that some of the falsos positivos were in fact guerrillas, but apart from sweeping allegations, I have been provided with no sustained evidence by the government to demonstrate that allegation. Evidence showing victims dressed in camouflage outfits which are neatly pressed, or wearing clean jungle boots which are 4 sizes too big for them, or left-handers holding guns in their right hand, or men with a single shot through the back of their necks, further undermines the suggestion that these were guerrillas killed in combat. A further problem concerns the systematic harassment of the survivors by the military. A woman from Soacha described how, in 2008, one of her sons disappeared and was reported killed in combat 2 days later. When another of her sons became active in pursuing the case, he received a series of threats. He was shot and killed earlier this year. Since then, the mother has also received death threats. This is part of a common pattern. The key question in much of this is who was responsible for these premeditated murders. On the one hand, I have found no evidence to suggest that these killings were carried out as a matter of official government policy, or that they were directed by or carried out with the knowledge of the President or successive defense ministers. On the other hand, the explanation favored by many in government, that the killings were carried out on a small scale by a few bad apples, is equally unsustainable. The sheer number of cases, their geographic spread, and the diversity of military units implicated indicate that these killings were carried out in a more or less systematic fashion by significant elements within the military. Starting in 2007, the government has taken important steps to stop and respond to these killings. They include disciplinary sanctions, increased cooperation with the ICRC and the UN, the installation of operational legal advisors to advise on specific military operations, increased oversight of payments to informers, the appointment of the Suarez Commission, the appointment of delegated inspectors to army divisions, requiring deaths in combat to be investigated first by judicial police, modifying award criteria, and creating a specialized unit in the Fiscalia. These encouraging steps demonstrate a good faith effort by the government to address past killings and prevent future ones. But there does remain a worrying gap between the policies and the practice. The number of successful prosecutions remains very low, although improved results are hoped for in the coming year. 3 problems stand out. The first is that the Fiscalia, and especially its Human Rights Unit, lack the requisite staff, resources, and training. a substantial increase in resources is essential. The second is that in some areas military judges ignore the rulings of the Constitutional Court and do all in their power to thwart the transfer of clear human rights cases to the ordinary justice system. The transfer of information is delayed or obstructed wherever possible, jurisdictional clashes are set up, and delaying tactics are standard. Delays, often of months or years, result, and the value of testimony and evidence is jeopardized. The good news is that there has been a significant, a major reduction in recorded allegations of extrajudicial executions by the military over the past 6 to 9 months. If this trend is confirmed, it will represent a welcome reversal of course, but the problem of impunity for past killings must still be addressed. Despite the significant steps taken by the government to reduce paramilitary violence, killings by groups that include formally demobilized paramilitaries continue at a disturbingly high rate across the country. The government needs to address the resurgence of these groups through comprehensive policies that focus on law enforcement, including strengthened investigative and prosecutorial functions, and the sustained engagement and protection of the affected communities. The government position is that these groups are criminal gangs and must be dealt with as such. While this approach may be appropriate in particular localities, it doesn't fully address the nature of and the threat presented by these armed non-state actors in different regions. Regardless of the name applied to them, a failure to address the reasons why these groups have emerged and the extent to which they permeate state institutions and terrorize civilian populations threatens to undermine the important security gains made by the government. It should urgently improve its efforts to effectively and promptly investigate, prosecute and punish killings by these forces. By all accounts, demobilized paramilitaries are a major part of the illegal armed groups. Post-2003 demobilization and reintegration policies have not prevented former paramilitaries from killing and engaging in other criminal acts. Although senior paramilitary leaders have been arrested, the economic and command and control structures of the paramilitaries do not appear to have been fully and effectively dismantled. In addition, there is an alarming level of impunity for former paramilitaries, and the investigation and prosecution of extrajudicial executions and other human rights violations by former paramilitaries appears to lag severely. Within Colombia's complex and sophisticated legal structure, the role of the Fiscalía is pivotal. The Fiscal General is chosen by the Supreme Court from a list of 3 individuals proposed by the President. Given the central and critical function of the Fiscalía, it is essential that the next Fiscal General be a person of independence, strength, and stature. Colombian civil society is vibrant and diverse. It makes invaluable contributions to public discourse and to raising awareness of human rights. But human rights defenders are frequently intimidated and threatened, and sometimes killed, often by private actors. They have been accused by high-level officials of being, or being close to, terrorists or guerrillas. Such statements have also been made against prosecutors and judges. These statements stigmatize those working to promote human rights and encourage an environment in which specific acts of threats and killings by private actors can take place. It is important for senior officials to cease the stigmatization of such groups. It's also important that a constructive space be found for civil society organizations and governments to communicate. I was struck by the extent of polarization in Colombia between NGO and government positions. It's my understanding that the current draft law on victims' rights, approved by the Commission set up to reconcile the texts approved in the Senate and House of Representatives, contains a definition of victim that includes victims of state agents and generally puts them on equal standing with victims of paramilitaries. It is, in my view, imperative that as this draft law moves forward, victims of both state and non-state actors continue to be treated equally. Finally,